Page.
Yes. Now, let's kindly share. Very interesting. Yes. Yeah. Kindly see page 101, paragraph 240.
Yes.
Yes. It is submitted that the governor cannot recognize the rebel MLAs and of political parties, as that would ring a death knell on the working of a multi-party democracy. The Sarkaria Commission's recommendations approved by this Honorable Court in Rameshwar Prasad also categorically emphasize the importance of sanctity of the party system and states that the governor, in arriving at a satisfaction to invite a chief minister, can only recognize alliance of parties and not an alliance of a party, in this case the BJP and rebel MLAs of another party. In this regard, para 65 of Rameshwar Prasad reads as follows. Para 4.11.04 of the Sarkaria Commission report specifically deals with a situation where no single party obtains absolute majority and provides the order of preference the governor should follow in selecting a chief minister. Now, this is final. What does it say? The order of preference suggested is 1, alliance of parties that was formed prior to the election. So parties, alliance of parties. 2, largest single party staking a claim to form the government with the support of others, including independents. Again, largest single party. 3, post-electoral coalition of parties with all the partners in the coalition joining the government. And 4, a post-electoral alliance of parties with some of the parties in the alliance forming a government and remaining parties, including independents, supporting the government from outside. There is no space for factions when the governor has to appoint a chief minister. Now, if all of Shiv Sena had gone to the BJP, governor will call for a floor test. The Shiv Sena itself had gone. Now, this is cast in stone. Now an argument is being raised, it doesn't matter, and which is why, I said to your lordship the consequences of it. Supposing 2 or 3 members of each political party who don't form the majority go to the governor and say that support of 6 of these people reduces the chief minister to a minority, therefore call for a floor test. It would be disastrous for democracy. That's the Ayaram Gayavaram principle that we gave up. Would 50 members of BJP today support Uddhav Thackeray? Will he call for a test? So, the whole propositions, the propositions that have been advanced by learned friends are all contrary to basic principles of constitutional law. I go back, to my submissions. So, para 20. Therefore, the recognition of a faction of a legislative party as the basis to cast a doubt on the confidence enjoyed by the government in the House would be an act of constitutional impropriety and legally mala fide. It is respectfully submitted that under the constitutional scheme, a member of a legislative assembly set up by a political party does not have any independent identity in the House. Dehors the political party on whose ticket he is elected to the House. The same is clear from the following. Now, this is important. Kindly see Article 170 of the Constitution and kindly see Sub-Article 1. Subject to the provisions of Article 333, the Legislative Assembly of each state shall consist of not more than 500, not less than 60 members chosen by direct election from territorial constituencies in the state. Well, I mentioned that to your lordships yesterday. Delimitation Commission, territorial constituencies, direct election from the territorial constituency. Now, kindly come, let's go to item 2. Under 7.1 of the Representation of Peoples Act 1950, the total number of seats in the Legislative Assembly of each state is as shown in the second schedule. Further, Section 7.3 of the Act provides that the extent of each assembly constituency shall be as determined by the orders of the Delimitation Commission made under the provisions of the Delimitation Act. I don't have to read it, Your losses may take it. That's correct. We'll waste time otherwise. Then come to 4. The first step in the process of nomination, Section 33 of the Representation of People Act, prescribes that each candidate desirous of being elected to a seat is required to deliver to the returning officer a nomination paper completed in the prescribed form. The provision itself differentiates between candidates set up by a recognized political party and those not set up by the party. That's Section 33. No, let's not read it. That's up. Nobody can doubt what I have said. So otherwise, it'll take time. Next, the relevant rule in the conduct of election rules pertaining to Section 33 is Rule 4, that deals with nomination papers and prescribes that each nomination paper must be completed as per the appropriate form. The appropriate form for the purposes of election to the Assembly is Form 2B. Part 1 of Form 2B applies to candidates set up by the recognized political party. Further, as per paragraph 13B of the symbols order, a candidate is deemed to be set up by a political party only if the political party provides a notice in Form B to the returning officer which contains the endorsement of the political party as to the approved candidate on its behalf. Hence, from the very initiation of the election process, the identity of a candidate for an election is as a representative of the political party by which it was set up. So the primacy is of the party. The legislature has no identity other than being a representative of the party. After the election, Section 66, 67 of the Act require the returning officer, once the counting of votes have been completed, to declare the election result and to communicate the same to the Election Commission and the Secretary of the House. That's very important, Melissa. Kindly see that, 67 of the.
That's okay. I think, you've paraphrased it, and there's no reason to doubt it.
Right. The reason is, what he sends is that he has been elected as C itself says, Malas, declaration of the. Sponsored by the political party and he has been duly elected. And the certificate also says the same thing. Would you go back to it, Mulats? Then, Mulats, item 9, corresponding rules of the conduct of election rules are Rule 64, 66, which prescribes 21C, Form 22 to be referred to by the returning officer. 21C deals with the format of declaration of the result of elections by the returning officer, and it explicitly requires the name of the recognized registered political party that has sponsored the candidate to be recorded. The same details are also required to be recorded in Form 22, which concerns the certificate election provided. Therefore, it is respectfully submitted that an elected member of the Legislative Assembly does not have any independent identity in the House except as a member of the political party to which he belongs. Accordingly, the governor could not have recognized any members of the legislature party, dehorsed their political party, and permitted them to make a representation against the government formed by the political party to which they belonged. So, Malas, he should have assumed that they continue to be in the Shiv Sena and that Shiv Sena had 52 members, and all the three parties together have 152 out of a house of 280. There was no occasion for him to say, have a floor test. And undisputedly, in the present case, the group of the Shiv Sena legislature party, represented by Eknath Shinde, is a faction of the legislature party, albeit a majority. The recognition of a majority of Shiv Sena MLAs by the governor to entertain a doubt about the confidence enjoyed by the government is in the teeth of the provisions of the 10th schedule and of the constitutional scheme related to election of members to the Legislative Assembly. Therefore, governor could not have asked the government headed by Uddhav Thackeray to seek a trust vote on the floor of the House on the 30th of June. On this basis, the governor's decision rather placed a premium on the unconstitutional acts of a faction in the legislature party, allowing them to topple an elected government. He knows, because he is not a member of the assembly, but he is part of the legislature. So he knows. He went outside the scheme of the 10th schedule as well as the scheme of the constitution to recognize a faction. Majority or minority doesn't matter. Governor is knowing fully well that a faction of the legislature party cannot be recognized under the Constitution.
Sorry, just to pause here. According to you, suppose there is a split, which is now, of course, not recognized.
Yes.
So what would have been a split under the unamended provisions of of the 10th schedule? But there is a group of legislators who would otherwise, who have otherwise left they say we have withdrawn support.
Correct.
Right, whether they withdrew support here or not, that you already made your point. Now, they will incur a disqualification because there is no split which is recognized by the 10th schedule now.
Yes.
Can the governor not then look at the numbers and say that, assuming that these people say that we have left, whether they incur a disqualification will be decided by the speaker, but this conduct of these people in doing something which is contrary to the 10th schedule also is liable to affect the strength of the House and the strength of the number of parties in that House, or the strength of the party in that House. Can he not do that?
No.
Because your argument is he can't do that at all.
No, forget the majority. This can happen where 2 or 3 or 4 members of each political party can do the same. What you're doing is, when there was no 10th schedule, what used to happen? The same thing. What my Lord is putting to me used to happen when the 10th schedule was not there.
Right.
So you are going back to a state where the 10th schedule is not there. That's my answer. Because that's exactly what your lordships are putting to me. Can't the governor, looking at the fact that these people now say they want to withdraw support, they may be disqualified as a separatist.
Then your submission would be that the governor can't call for a trust vote in oblivious to the provisions of the 10th schedule.
No, forget the 10th schedule. He can't call for a trust vote, Mulaz, by recognizing a faction in a political party which has no identity, which has no constitutional identity. That's my submission. Mulaz, your lordships are now looking at them as a group. They are not a group, they are individuals. There is no concept of a group within the legislature. Each is an individual. And government formation is based only on alliances. And therefore, Mulaz, calling a trust vote has to be based also on alliances, if it's been reduced to a minority. That's accepted now by Rameshwar Prasad, Mulaz. They could have followed, Mulaz, the Madhya Pradesh model. Resigned. No, but they wanted to be chief ministers and posts, Mulaz, so naturally, Mulaz. They could have followed the other model. Mulaz, that also is a constitutional issue which one day your lordships will decide. That's also another issue. The collective decision to resign as a group, Mulaz, is something which is very suspect in constitutional law. Suddenly, all of them together one day decide we all must resign.
This is in line with Kyoto, unless we question Kyoto.
Mulaz, I have always questioned it. I have always questioned it, but that's another issue, Mulaz.
But it also has a bearing on coalition governments,
Yes.
particularly regional parties.
Yes.
regional parties, this argument could sometimes be very dangerous also, because there is absolutely no freedom in the party except for one leader. Many a times it's a family which runs it, and there is no scope of anybody else coming into the fray
Well, in fact,
and setting up an alternative, because it's impossible.
Well-
Virtually, we are interpreting the constitution to say that it is just not possible for any legislators.
well, in fact, this has been my grievance. What happens, Millers, in the United States and in the UK, Millers,
Parties.
a president, Millers, of the Republican Party will reach out to Democrats to get a bill passed. The insurance, actually, Barack Obama had to reach out to the Republicans for his insurance bill. And in the UK, the same thing, the Conservative Party or the Labour Party reaches out to the opposition members. There is no such thing as defection. This is the problem. But anyway, Malas, we are in another era.
Yeah.
At the moment, we are on the law as it stands today. So we go back to the Gairam regime, where there is no 10th schedule, and you can actually move the governor for toppling any government you want at any time you want. Yeah, a few people. Malas, there is an NCP case where only four people of the NCP, Malas, actually went away. There were only 4 members. All of them went away.